Well, hello everyone, and welcome back to AJ102 Introduction to Criminal Justice. My name is Tony Farrar, and of course, I am your instructor for this semester. So, this week's lecture is going to cover Chapter 4, where we're going to take a look at criminal law, substance, and procedure. So, this chapter is going to cover the rules that define crimes, set out their punishments, and mandate the procedures for carrying out the criminal justice process. Now, ordinarily, we think of, criminals as being on the opposing, team, if you will, relative to law enforcement. Sadly, though, criminal justice officials, including law enforcement sometimes, cross the line from time to time. And sometimes their actions even make ordinary criminals seem tame by comparison. So it is important to remember, though, that police officers are bound by the same criminal laws as the rest of us. All right. So we're gonna jump into and talk about the foundations of criminal law, both substance and procedure. But let's look at a couple of the learning objectives first. So we want to be able to identify and list the similarities and differences between what they call substantive and procedural criminal law, and then between civil and public law. Discuss the concept of substantive criminal law and be familiar with how it started. Look at the sources of criminal law. Describe how crimes are actually classified. Identify the elements of a crime. Discuss some defenses or excuses and justifications as defenses for crime. Discuss the concept of criminal procedure. Identify which amendments to the Constitution are most important to the justice system. And that's kind of a really interesting thought. And then list the elements of due process of law. So a lot of content. So we probably need to just kind of jump right into this here. So in modern U.S. society, the law governs nearly all phases of human enterprise, including commerce, family life, property transfer, and the regulation of personal conflict. And it contains elements that control personal relationships between individuals and the public relationships between individuals in the government. Okay? The former is known as civil law, and the latter is called criminal law. And with that, know that the law can be divided into four broad categories. So really quick, civil law, by definition, all law that is not criminal, including torts, contracts, personal property, etc. Criminal law is a little different, right? That would be the body of rules that define crimes, set out their punishment, and mandate the procedures for carrying out the criminal justice process. So there's the two differences by definition. So let's start off and let's look at substantive criminal law. So the branch of the law that defines crimes and their punishment is known as substantive criminal law. It involves such things as the mental and physical elements of a crime, the crime category, and criminal defenses. So substantive defines the factual elements of criminal offenses. So an example would be robbery. It requires that the prosecutor establish the intentional, forcible taking of property from another person with intent to permanently deprive the property from that person. So, the crime and its elements. So you have to be able to show all of that. And that's part of substantive criminal law. Procedural criminal law. Law that sets out the basic rules of practice in the criminal justice system. Those are called procedural laws. And it kind of makes sense because it's the procedure of it, right? So some elements of the law of criminal procedure would be things like rules of evidence, the laws of arrest, the law of search and seizure, questions of appeal, jury selection, and the right to counsel. All of those fall underneath procedural criminal law. So understand that that's kind of more of the procedure on how things are done. Okay, not as opposed to the elements or the category, etc. So criminal procedure then addresses the procedures involved in the investigation, detection, and prosecution of criminal offenses. The enforcement of criminal law is influenced by criminal procedure. Okay, so an example in the case of that robbery we talked about, this might entail interrogating the suspects and doing it within the confines of the law. Identification of the suspect and doing it within the confines of the law. Searching for weapons and doing it within the confines of the law. And arrest and prosecution of the suspect and doing it within the confines of procedural law. So hopefully those two things kind of make sense now. So now you know substantive and now you know procedural. Civil law. So this sets the set of rules governing, again, relationships between private parties, including both individuals and organizations, is known as civil law. So civil law is used to resolve, control, and shape such personal interactions as contracts, wills, trusts, property ownership, and commerce. Okay? The element of civil law that is most relevant to criminal justice would be what we call torts. And this is the law of personal injury. Okay? Civil law is more concerned with compensating injuries, financial, right, than it is with punishment. Punitive damages, money beyond compensation intended to punish or deter. So hopefully that kind of makes sense as well. And then finally we have public law, the branch of law that deals with the government and its relationships with individuals or other governments. So public law governs the administration and regulation of city, county, state, and federal government agencies. So that would be public law. So some of the goals, when we go back and we kind of take a look now at going back to substantive criminal law. Let's note some of the goals. First would be to enforce social control, distribute retribution, express public opinion and morality, deter criminal behavior, punish wrongdoing, maintain social order, and provide restoration. So these are all goals of substantive criminal law. And remember that this is the branch of law that defines crimes and their punishment. And it also talks about elements to a crime, crime categories, and criminal defenses. Okay, so before we move on to the development of criminal law, let's just kind of take note that the four elements of the law that I just kind of spoke of can be interrelated. Okay, so a crime victim may also sue the perpetrator for damages in civil court, and some crime victims may forego criminal action and choose to file only a tort claim. It is also possible to seek civil damages from a perpetrator even if that person is found not guilty of a crime. If you remember the AJ Simpson case, the families of Nicole Brown and Ron Goldman successfully sued O.J. Simpson for damages, and they did this because the evidentiary standard in a tort case is less than that which you have to meet for a criminal conviction. And what I mean by that is that civil court defendants may be found guilty by what they call a preponderance of the evidence, whereas In a criminal court, you have to be found guilty beyond a reasonable doubt, which is the highest level that you can get. So hopefully you can see how those things kind of intertwine, if you will. Okay, so now the development of criminal law. So the roots of criminal codes, if you will, well, let me back up. The criminal law is a living document. We do need to understand that is consistently evolving to keep pace with society. So we already know the substantive criminal law defines crime and punishment in U.S. society. And each state government and the federal government has its own criminal code, developed over many generations and incorporating moral beliefs, social values, and political, economic, and other societal concerns, if you will. And again, the goal of substantive criminal law, they're listed kind of in your textbook as well. So the rules designed to implement the substantive law are known again as procedural law. In contrast to the substantive law, that procedural law is concerned with the process, right? The legal steps through which an offender passes, commencing with initial criminal investigation and concluding with going to prison and then maybe being released, etc. So, okay, I just want to make sure that we had a really good handle on those foundations. All right, so now let's talk a little bit about the history of criminal law. So, the roots of the criminal codes used in the United States can be traced back to such early charters as the Babylonian Code of Hammurabi, and also the Mosaic Code of the Israelites, and the Roman 12 tablets. So we can kind of go all the way back here. And, kind of a little bit more, although the early formal codes were lost during the Dark Ages, German and Anglo-Saxon societies developed legal systems featuring monetary compensation called weirgeld for criminal violations. Now, weirgeld, when you break it down, were means worth and refers to what the person and therefore the crime was worth for criminal violation. So it kind of refers more to blood money, if you will. So kind of moving forward a little bit, guilt was determined by two methods. One was called compurgation, which involved having the accused person swear an oath of innocence while being backed up by a group of 12 to 25 kind of oath helpers who would testify to that person's character. And two, claims of innocence and ordeal, which were based on the principle that divine forces would not allow an innocent person to be harmed. So again, we're talking kind of going back in the development of criminal law. So determining guilt by ordeal involved such measures as having the accused place his or her hand in boiling water or hold a hot iron in their hand. And if the wounds didn't heal, the accused was deemed guilty. So kind of an interesting thing, right? And then they had trial by combat, allowed the accused to challenge his accuser with the outcome determining your guilt or innocence. And back then, when we're talking a long time ago, but back then punishments included public flogging, branding, beheading, and burning. So again, we're kind of moving forward a little bit, if you will. After the Norman conquest in England in 1066, royal judges began to travel throughout the land holding court in each country. And here the judge would decide what to do in each case using basically customs and rules of conduct as their guide, a system called stare decisis. And why is that important? Well, because we see that same term today, stare decisis. So the Latin term meaning to stand by things decided. It is a legal doctrine in which courts generally follow the application of the law as decided in similar prior cases, which is referred to as following precedent, which is what the United States Supreme Court does, is that they will follow prior or precedent cases when they are looking to decide a similar case. So again, by definition, stare decisis, to stand by decided cases, the legal principle by which the decision or holding in an earlier case becomes the standard by which subsequent cases are to be judged, etc. So hopefully that kind of makes a little bit of sense. All right, so kind of continuing now, those royal judges actually began to publish their decisions in local cases. Judges began to use these written decisions as a basis for their decision making, and eventually a fixed body of legal rules and principles came about. Okay, and eventually the system evolved into a common law that incorporated local custom and practice into a larger national code. And if the new rules were successfully applied in a number of different cases, they would become precedent, which would be commonly applied in all similar cases, right? So that's kind of a little bit of information on common law. So common law, by definition, these are laws originating from use and custom rather than from written statutes. So it kind of refers to non-statutory, meaning written, customs, traditions, and precedents that help make judicial decision making. And here you can look at, you know, kind of the evolution of common law all the way from the Code of Hammurabi to the 12 tablets. You can go all the way here. Roman law is codified here. You have William the Conqueror. You have King Henry II, and then here common law principles. So that's kind of just a little common law lesson there. All right. So just kind of finishing up with this particular section. Okay. So crimes such as murder, burglary, arson, and rape are referred to as mala in se crimes. And what that means is these are crimes that are inherently evil and depraved, right? Murder, etc. Okay. And statutory crimes are a little bit different. Those are what we call mala prohibitum or prohibita. You can use either one. And these are crimes that reflect existing social and economic conditions. And they're deemed wrong or bad because they're prohibited. They're statutory, but it doesn't really mean that they are, you know, immoral. So there's something that's kind of written down, right? So it could be like drinking in public, and there's a section on the books for that. So, you know, it's wrong. It doesn't mean it's immoral, but it's wrong because it's statutorily prohibited. Speeding, you know, things like that. Okay. Mala in se, again, crimes that are inherently evil and depraved. Mala prohibitum or prohibita, whichever one you want. Crimes that reflect existing social and economic conditions. They're bad because they're statutorily prohibited. So hopefully that kind of makes sense as well. Okay, so now that we've kind of, you know, walked through, you know, a little bit of history, if you will, let's now look at some sources of criminal law. So where does this stuff come from, right? So the contemporary U.S. legal system is codified by the state legislatures and the U.S. Congress. Okay. Each jurisdiction precisely defines crime in its legal code and sets out the appropriate punishment. So it would be like the California Penal Code, which would have all of the codes listed, right? They're codified, they're written, okay? And they would also have the punishment. So note that the content of the law may also be influenced by judicial decision making. Regardless of its source, all criminal law in the United States must conform to the rules and dictates of the U.S. Constitution. And any criminal law that even appears to conflict with the various provisions and articles of the Constitution must reflect a compelling need to protect public safety or morals. Okay, so these are talking again about sources of criminal law. So criminal laws, when we talk about constitutional limits and things like that, criminal laws have been interpreted as violating constitutional principles if they are too vague or too broad to give clear meaning to their intent. So each state and the federal government has developed, again, its own body of criminal law that defines and grades offenses, sets levels of punishment, and classifies crimes into categories. Okay? So, and when you kind of look at a couple of different categories, we'll take a look at it in just a minute. So one would be prohibits laws that makes a person's status a crime, cruel and or capricious, and then what they call bills of attainder, which inflict punishment without a trial. And then finally we have what's called ex post facto. And we're going to take a look at that in just a second. But just note that the Constitution, again, prohibits certain laws, okay? And some of those would be prohibiting laws that make a person's status a crime. The Constitution also limits laws that are overly cruel, okay, or what they call capricious, okay? And that could be something like the death penalty, okay? And then what we call bills of attainder, which is a kind of a legal phrase, talking about limits laws that inflict punishment without a trial. So that kind of makes sense. All right, and then finally we're going to talk about ex post facto. So this is a law that makes an act criminal after it was committed or retroactively increases the penalty for a crime. Such laws are forbidden by the Constitution. So any law that makes the action done before the passing of the law and which was innocent when done criminal and punishes such action. A law that makes a crime more serious after the fact than it was first committed. So, again, laws can't be retroactive. If something was legal today and then a week from now it's illegal, you can't go back and punish the person for it. Does that kind of make sense? That would be what they call an ex post facto law. So again, a couple other things. Under ex post facto, a law that inflicts greater punishment than was available when the crime was first committed, or a law that makes convicting the offender easier than it was at the time the offender committed the crime. So these all fall under the ex post facto. Okay, so let's talk now about classifying crimes. The decision of how a crime should be classified rests with the individual jurisdiction. And again, as I talked about, each state has developed its own body of criminal laws and consequently determines its own penalties for the crimes. And here I've got a picture of the California Penal Code. So thus, the criminal law of a given state defines and grades offenses, sets levels of punishments, and classifies crimes into different categories. And it is going to be different from state to state, so just kind of understand that. Now, generally, and in California, but generally, crimes are classified into 3 different groups: felonies, misdemeanors, and infractions. Okay, and these are the most common classifications in the United States. And the distinction here between these is based primarily on the degree of seriousness of the crime. So distinguishing between a felony and a misdemeanor could be difficult, and sometimes these cases are actually wobblers. It could be a misdemeanor and it could be a felony. So just kind of, understand that. But just, generally speaking, the most common definition of a felony is a crime punishable in the statute by death or imprisonment in a state or federal prison. Okay, so typically punishable by more than 1 year in prison. That's how a lot of states might look at it. Okay, and again, remember I talked about wobblers and things like that too. Now, for a misdemeanor, this would be something punishable by a fine, probation, or up to 1 year in jail in a county jail facility, not a state prison, okay, or a federal prison. It would be a county jail facility or a city jail, but typically it's a county jail facility, up to 1 year. So that would be a misdemeanor. And then again, remember, there's wobblers. And if you look at the picture right here, you can see that, sometimes there's a wobbler here where there are some sections that could be either or. Okay. And then the last one would be an infraction. And this is typically punished by fine or points against your driving record. No jail time, no probation, no parole, no prison, none of that kind of stuff like that. And the easiest way to distinguish that would be basically traffic violations, okay, or something similar to that, a traffic citation. So those are the general classifications. Remember that things do change from state to state, but typically these would be what we call the 3. So felonies, if we were to kind of look them up, those would be things like, just to kind of throw out a few: murder, robbery, and rape. Misdemeanors could be DUI, could be vandalism, could be assault. Infractions could be a traffic cite. Okay, so these are just kind of giving you a couple of examples on how these fall into these different categories. All right, so now that we've kind of classified the crimes and we know that there's felonies, misdemeanors, infractions, etc., let's take a look at the legal definition of a crime. So what is that, right? What is the legal definition of a crime? Where, nearly all common law crimes contain both mental and physical elements. For example, to commit the crime of burglary, let's just go with California, offenders have to do the following. And you have to enter a dwelling, and there's other types of dwellings, etc., with a certain intent specifically to do this. So you have to enter a dwelling with specific intent to commit grand theft or petty larceny, or any other felony. Those are the elements of burglary. Okay? So stay with me. It's kind of hard to, understand. And your textbook has a little bit of a definition only because it uses kind of an Eastern, the elements are from an Eastern kind of burglary, but we're going to use the West Coast here in California. So now, to convict a person of a crime, the prosecution, again, is going to have to determine all of those elements. Okay, all those elements in there. And part of this whole process, understand that crimes, almost all common law crimes, contain both mental and physical elements. Okay? To constitute a crime, the law requires a connection that's made between the mens rea and the actus reus, showing that the offender's conduct was the cause of that criminal act. So now let's go back and define two things, and it'll make more sense. So the phrase actus reus, an illegal act or failure to act when legally required. That's an element of a crime, right? There has to be an act or a failure to act. And then mens rea is guilty mind, which means the intent to commit the criminal act. So to constitute a crime, the law requires some type of connection between the illegal act and the guilty mind, showing that the offender's conduct was the cause of the criminal act. So here, this will kind of clear it up. So in general, to commit that crime of burglary, we had those elements, remember those elements? The accused, the suspect, engaged in the act, had the intent to commit the crime, the mens rea, so we have the act is the actus reus. Okay, intent is the mens rea. Both the actus reus and mens rea were concurrently present, right? Happened kind of one after another or at the same time. Therefore, the defendant's actions were what we call the proximate cause of the harm, which is the theft. And the actual harm was caused. So does that kind of make sense? So enter the dwelling, the act, with the specific intent. Remember, these are the elements. That's the mens rea. To commit the theft, okay, both the act and mens rea were present at the same time, or any other felony, which resulted in the harm. So that's a good way to kind of break down a crime, if you will. Okay? All right. And then here's kind of a little chart that shows the legal essence of criminal conduct. Okay? So we have the mens rea, we have the actus rea, we have the concurrence between the two. Oh, and then don't forget, at some point we're going to throw in this bubble because that's the legal defense. Okay, if we took out this blue bubble, that would be committing a crime, but now we have to add in the possibility of a legal defense, and we'll do that in just a few. All right, so we're right about at the 32-minute mark. Let's just do a couple more, and then we'll take a quick break, and then we'll jump back in. So certain statutory offenses exist where mens rea is not essential. Okay, and these offenses fall within a category known as public safety or strict liability crimes. And these are things like traffic crimes, public safety, and business crimes are typically strict liability. They're defined by the act itself, irrespective of your intent. So if you're speeding, even though you might have an excuse, hey, it said 65, and 65 is the speed limit. So regardless of your excuse, it's still a violation. Okay, irrespective of your intent, your intent, and that's called, basically what we call strict liability crimes or public safety type crimes. Okay, and then the third element needed to prove that a crime was committed is the immediate relationship to or concurrence of the act with the criminal intent. We talked about that in the burglary example. So just note that the law requires that the offender's conduct be the proximate cause for any injury resulting from the criminal act. So for an act to be considered a crime, the actor's willingness to cause harm has to be proven. So it's probably more than you thought. There's a lot to a lot of these different things, right? When it comes to criminal law. Okay, so we're going to stop here. We're going to take our quick break, and then we'll come back and we will jump into criminal defenses. So this will conclude part 1 of chapter 4.